morning and welcome back to our series on security clearance appeals. This is your host, Attorney Alan Edmunds, and I am delighted to share my experience and expertise with you about a very, very important guideline, which is Guideline B, Foreign Influence. These are contained in the National Security Adjudicative Guidelines, and as many of you know from both my YouTube videos and my podcasts, these guidelines are used by all federal agencies. They may slap a different cover page on them, but the content or the guts of the guideline is the same for all agencies. And they're very important for you, the applicant, seeking a security clearance for the first time or renewing a clearance when over the last 5 years, you have been involved in some type of behavior or allegation that the government could determine is a risk to national security, and hence you get a statement of reasons. You know from my previous podcast that a SOR or statement of reasons is a written document. It's a formal notice to you, the applicant, that your security clearance is being denied, and it states the reasons for that denial, and it demands a formal response that is sufficient enough to receive a favorable review. And this gets me to something that is very important, and I want to take a few minutes right now to divert a little bit and talk about a statement of reasons or a notice of proposed action or a letter of intent. You people get these and you look at them and you think that you can respond yourself, and you try it, you do it, you send it in, or you use a union rep and you send in a response that quite honestly is totally inadequate. My question to you is, you get through college, you've done very well in college, maybe you went to engineering, maybe you went to computer science, you get this degree, some of you go on for a master's degree. I have clients that are double Harvard, double Stanford, they got their undergrad and graduate degrees at Stanford, and they get out with an MBA in computer science or engineering or mathematics. It could be any one of 50 concentrations. Then you apply to a big company like Lockheed Martin or Raytheon, and you get the dream job. You get an incredible dream job, and your salary starts at $150K, and you start the job, and while you're at the job, the final adjudication comes in from your security clearance application. You filled out an SF-86. They started you at your job. You're working. You love it. It's a culmination of all your hard work. And then you get a statement of reasons or an SOR. And some of you mistakenly, because of your talent and your intellect, try and handle this challenge, this process yourself. And it really surprises me because you're moving everything on the table. It's like a poker game, and you're putting all your chips on the table and you're saying, no problem with this SOR. I've talked to a bunch of people. I talked to my FSO, and I can do this myself. And you do it yourself and you fail. And then you say, my goodness, I thought this was something I could handle. You send in an answer to the SOR and it fails. And the government says, well, you can submit another written response, or you can go to a hearing. And some of you say, well, I think I'll go to the hearing, and you actually go by yourself. And you get in the hearing, you're against a U.S. attorney. It's a formal court hearing with a judge and a court reporter, and you get annihilated. You go to the hearing, you get humiliated and embarrassed, and you lose. And now, 4 years of college, maybe 3 additional years or 2 additional years of an MBA, and you've lost your dream job. Your dream shot is in shatters at your feet, And you have only yourself to blame because what were you trying to do? You're trying to save money. So you're trying to save a couple grand, avoid getting an attorney. You have this can do attitude. And it just shatters me when I see these stories because then these people call me up and they say, "What can I do?" And I ask, "Well, how far did you go by yourself?" And invariably they say, "Well, I answered the SOR. That didn't work. And then I went to the hearing by myself and that didn't work. And now I'm on my last ground, my last chance for an appeal." And that's a deep, deep hole to get out of. The government will tell you, "Oh, you can reapply in 1 year." And that's true. But after the first year following a denial, the success rate is dismal. So, my question to you is why are you doing this? Why are you pretending to handle a legal case by yourself? And you have to resist the temptation of both the government attorney saying, "Oh, you can do this yourself. Don't worry. The judge is very understanding," or an FSO that says, "Well, I'll give you some guidance. You can do this yourself," or a union rep that says, "We can help you." And they can help you. And I'm not disparaging union reps, but they seldom go to hearings. And you rely on that advice and you so readily put your career on the poker table. You're all in, and then you lose. Please don't consider doing this. Okay, the cost of an attorney, at least at the Edmunds law firm, is not prohibitive. If you're making 150K a year, it sure doesn't approach even 5% of that through the whole process. So think about that and get help, get professional help. I've been doing this for 45 years. And I have offices across the United States, and we're going to treat you uh, incredibly well. You're an important client. Every client is important. And we're going to do a 20 to 25 page response to your statement of reasons. And we're going to attach all the components that are required. And we win a lot of these responses without any further processing. That means you don't go to a hearing. And then, secondly, a lot of our cases we win 2 or 3 days before the hearing. When the government receives our trial notebook, they call me on the phone and they say, "We're going to withdraw the SOR." So you win. So those are the opportunities that you have with the Edmunds Law Firm at 800-481-2526 that you don't have yourself and you don't have with other attorneys that don't have the experience. So let's get back to this guideline B because you called me on this. It's one of the most listened podcasts, and your questions are fantastic. So I want to concentrate on that. I've already told you that guideline B is the contained in the National Security Adjudicative Guidelines, and the concern is foreign contacts and interests that include but not limited to business, financial, property interests are a national security concern if they result in divided allegiance. And divided allegiance is a key phrase. Divided allegiance means, yes, you're in the United States, but you still have a foot in your former country of birth or origin. And we're concerned because you have a business there, you have bank accounts there, you have relatives there that have received government retirements, or you have relatives that have served in the military. There are numerous connections called a nexus that you might have with the country that you